Okay, on the record in the matter of Kim Berry Moskovsky versus Andrew Warner and Dominic Sturdivant, file number 24-00289, council appearance.
Good afternoon, Your Honor. Don Keskey on behalf of plaintiff.
Good day, sir.
Andrew Warner.
Okay, today was the date set for hearing for non-payment of rent. Did you all come to resolution at all?
Yes, Your Honor, we entered into a consent judgment. The amounts for possession judgment only, not a money judgment, and filled in the judgment form and signed by both parties.
I feel.
So one issue closer to like right, the first one after the 1045.
Yeah, my question is long versus last. I don't know why it doesn't have anything. And that's not even mine, or is that true? Doesn't have anything. Okay. Okay, and where is Dominic Sturdivant?
Passed away.
Right? Did we dismiss against Dominic? I'm trying to see if it was dismissed. I don't see it.
I think you made a note of it the last couple of
I
times.
need a dismissal for it so that it doesn't come up. Okay, so you want to enter into consent judgment today, sir? And so you understand that you have the right to be represented by an attorney today? You're gonna give up that right? You have the right to proceed to a trial. You could have demanded a jury trial. You want to give up your right to trial? I can't hear you.
Yes.
Okay, so you want judgment to enter against you by consent whereby you agree that you owe the past due amount for a possession judgment, $14,160 plus $199.73, for a total of $14,359.73. That you'll pay that or vacate on or before July 8th, 2024, correct?
Yes, sir.
And you've signed there on the bottom. You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you have just waived on the record, you can request to have this judgment set aside. You need to come in within 3 business days for that, okay? I will get you a copy of this. Do you have any questions for today?
Your Honor, we should check that the order, the judgment includes the name of Kim Berry's Smokoski. RPM is the agent for that plaintiff, but I know the clerk sometimes leads with the property owner.
I'm sorry, you said check what?
The,
I have Renaissance Property Management. He's named as the plaintiff.
yes, but it's Kim Berry's Smokoski, care of Renaissance Property Management.
The plaintiff, so the plaintiff's name needs to be or not the care of. We don't really care about the care of on this paperwork.
Well, if, I think the clerk is running the cases with the actual property owner name, not the management company.
Correct, because the management company is not the owner, and it needs to be the owner's name. Kim Berry.
Kim Berry Smokoski,
Smokoski.
but by an agent, Renaissance Property.
I recognize it, but I know that they'll kick this out if it's not the right, or if it's not the owner's name.
Yeah.
Okay, any additional matters for today's record?
You want us,
I changed it.
you want us to file on my file?
No, we're doing it right now.
Oh,
That's why we was
You said what?
submitting dismissals. Because it's not getting into all day.
That's not getting standard to.
Yeah, I think it would be easier if they did it.
Well, we were told that if we take it, we have to do it.
If you let somebody, yeah, so they can just submit it. And then sign it, and you can sign it.
Oh, I don't know why is it not getting into my file?
I don't know. We keep having that issue, we have to like,
And she can see it. It's going in there. They're just not seeing it.
I'm not sure. what's
Yeah,
happening until
they'll
they
figure it out. They want to use on base. They need to figure it out. You're all set for today.
yeah, thank you.
You're welcome. On the record in the matter of Stone Ridge Meadows versus Charles Goodwin and Evan Round, file number 24-01820. Council appearance.
Your Honor, Nicholas Darlinghouse, on behalf of plaintiff Stone Ridge Meadows Apartment.
Okay, I do see a person identified as
We're,
Charles Goodwin.
we're both here, Your Honor.
Okay, then that's Evan Round sitting next to you, Mr. Goodwin. Okay. You were supposed to appear in person. Why are you not here?
I apologize. I was not aware that we had to appear in person.
Today's the date and time set for a hearing, and you have a consent judgment. Is that what it is?
I do, Your Honor.
Please place the terms on the record.
Thank you, Your Honor. Your Honor, we have come to terms on a consent judgment. The possession portion of the judgment states that there is a current rent to retain possession of $6,800 plus court costs of $297.73, which brings the total to retain possession $7,097.73. The plaintiff can apply for an order of eviction if the defendant does not pay on or before July 8th of 2024. Acceptance of partial payment will not prevent an eviction, an order of eviction. There is also a money judgment prorated through today's date of $6,100 and court costs of $297.73 for a total money judgment of $6,397.73. And MCR 4.201 was explained to the parties, and I got permission to sign on behalf of the defendants.
You can approach. Okay, Mr. Goodwin and Ms. Round, is what Mr. Garlinghouse stated accurate?
Correct, yes.
Okay, so you want the judgment to enter against you by consent, indicating that you agree that money is due for possession judgment in the amount of $6,800 for the amount of past due rent to retain, plus court costs, $297.73, for a total amount due of $7,097.73, that you'll pay that or vacate the property by July 8, 2024, correct?
Correct.
Yes.
You have the right, okay, very good. You have the right to be represented by an attorney today. You understood that, right?
Correct.
Is that a yes, ma'am?
Yes.
And you're willing to waive that right today?
Yes.
Yes.
You also have the right to proceed to a jury trial. You could demand a jury. I think you want to waive your right to trial.
Yes.
Yes.
Anybody threatening you to give up those rights?
No.
You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you just waived, you can return to the court and request to have this judgment set aside. You'll explain to the court how it was that you misunderstood the rights that you waived. We'll get you a copy of this sent out to you in the mail. Do you have any questions at this time?
No.
Any additional matters for the record, counsel?
Nothing further for me on this one, Your Honor.
Thank you both. You're all set.
Thank
you.
you.
You're welcome. On the record, in the matter of Stone Ridge Meadows versus Emeka Achanu, file number 24-01822. Council appearance.
Good afternoon again, Your Honor. Nicholas Darlinghouse on behalf of the plaintiff, and my representative of my client is here as well, Ms. Wendy Martin.
Are we having a hearing?
It looks that way, Your Honor.
Okay. Is she a representative or is she a witness?
Both, Your Honor.
Okay. In your name?
Emeka Achanu.
Okay. And you were unable to have or come to resolution today?
Yes.
Okay. You can have a seat. You're representing yourself, sir?
Yes.
You can proceed with your evidence, counsel.
Thank you, Your Honor. Plaintiff has just one witness in this matter, Ms. Wendy Martin.
Take the stand, ma'am. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
You can have a seat. You say your name is Wendy Martin?
With an I, Wendy with an I.
Wendy, I was gonna ask what's a common spelling. Okay, sounds good. You can proceed, counsel.
Thank you, Your Honor. Ms. Martin, can you please identify your position with Stone Ridge Meadows Apartments?
I am vice president of multi-management, which manages.
And in that position, are you familiar with the books and records associated with the units that are in Stone Ridge Meadows?
Yeah.
And specifically, you're familiar with the books and records regarding 5505 A North Road, apartment number 4?
Yes.
All right. And is the defendant a resident in that unit?
Yes.
Okay. During the course of your normal business, do you keep a tenant ledger
Yes.
showing, and that shows all payments and amounts owing, is that correct?
Yes.
All right. Your Honor, plaintiff has proposed exhibit of the ledger. Yes. A or 1?
One.
1.
Have you, you've gotten it marked already?
I do not.
Okay. You can get it marked. You can get it marked. This is the whole
Yes.
exhibit. It's just one. Okay.
Oh, yeah. Just 4 copies of the same exhibit.
Oh, okay. Oh, yeah, that's
Okay.
fine.
All right. Ms. Martin, this has been labeled as plaintiff's proposed exhibit 1. Is that the ledger for the apartments at 5505 K North Road number 4?
Yes.
Okay. Your Honor, I move to enter plaintiff's proposed exhibit 1.
Any objection? Are you objecting to this as evidence?
Can you explain to me what you mean by that?
So the rules of evidence require that only certain things be admitted. They have to be relevant. They have to be, can't be hearsay, all that kind of stuff. So I'm asking you if you have an issue with that being an exhibit.
I do not have this time.
Okay, so the plaintiff's 1 is admitted.
You have a copy of the court of appeals? Ms. Martin, according to the ledger, what is the amount owing as of this date?
$4,279.50.
And this record reflects all payments that the defendant has made over the course of their tenancy as well, correct?
I can read the ledger. This one as far back as July 2022, yes.
Okay. And these records are accurate to the best of your knowledge?
Yes.
And as of today's date, the defendant still remains in possession of the unit in question, correct?
Yes.
All right. I have nothing further with this witness here.
Do you have questions for this witness, sir?
No, I do not.
Thank you. And that's your only witness?
That's my only witness, Your Honor.
Okay, thank you. And are you calling witnesses or are you gonna give testimony today, sir?
I'll give a testimony today.
Give your right hand up. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
Thank you. You can put your hand down. Okay, and so you understood that there was a allegation of a past due amount of rent owed, correct?
Correct.
And you believe you have evidence of whether that's testimony or otherwise to support a lawful reason as to why you should not be responsible for that amount?
Yes.
Okay, tell me why.
So first, the issues came into play was I was never given a new lease to renew my lease after my second renewal of my lease. Or excuse me, after the first renewal of my lease. And when I made multiple attempts with the leasing office to either figure out the discrepancies of the money they said owed or to get a new lease out to me, it was never given to me. I was always told that they were going to get back to me, which they never did. The money that they're saying is owed is they're saying that I'm on a month-to-month lease that came into effect because I never signed a new lease that I never received, that I've asked for multiple times and never got from them. Also, as well too, I've had multiple maintenance issues that I'm dealing with them. Also,
What are
as
those
mold-
issues?
as far as the maintenance issues is unupdated appliances, some appliances that don't work flat out.
What are they?
My dishwasher does not work. My bathroom has mold in it. I have cabinets with mold in it.
You have
I-
pictures?
I do
Where are they?
on my phone.
How am I supposed to see them?
Is there a way for me to email or anything like that?
No, you were supposed to bring your evidence to court today.
Okay,
So how are you have pictures of mold in your bathroom and cabinets,
yes,
and you showed it to plaintiff's counsel?
no, I do not.
Okay, you complained of mold?
Yes, I've had multiple maintenance complaints of that, and they've given me mold and mold spray and told me to spray it myself.
Okay, in the dishwasher, what other appliances aren't working?
I've had broken racks in my bathroom,
Racks or rats?
towel racks.
Towel racks?
Yeah, I had a broken towel rack in my bathroom
Okay,
as
so,
well. That was not working. Also, there needs to be repairs made to my bathroom as well.
what are those repairs?
There needs to be a repair to the floor in the bathroom itself.
What's the matter with the floor?
There's a burn mark on the floor of a small burn I had in my bathroom.
How did the burn happen?
An insect that wasn't put all the way out ignited the trash can. So
I'm sorry, what was, instant ignited, so you caused the fire?
yes, I caused the fire, and then there was a burn on the bottom of the on the tile of the floor. They told me to make a request and they will fix those matters, and they did not.
And bill you for the damage? Is that what they said?
They didn't tell me that they were gonna bill
Oh,
me.
you think
that.
they should be responsible for fixing your burn?
They don't have to be. At the time, I was just told that they were gonna fix it for free. That's what I was told.
Okay. I need to know what are the issues or conditions within the property, other than the mold, that you believe made the property uninhabitable.
As far as right now, it's the moment.
The mold in the bathroom and cabinets, and you say you have pictures that you can email?
I can print the pictures off of my phone, but no, I did not have them prepared.
They're on your phone now? Send them to Judge Simmons' courtroom
Okay.
at lansingmi.gov. Who's on the Samsung SM? What's your name, ma'am?
Evangelina Rodriguez.
You and Ms. Lopez are supposed to be here in person.
I had called and requested it to be on Zoom because I'm in the hospital with my daughter.
Okay, why is Ms. Rodriguez not present in the courtroom?
I didn't know I had to be in person. I've never received anything. I co-signed for her and she's been the one telling me.
Okay, yeah, all hearings are in person.
I apologize. I didn't know that.
Okay, Ms. Lopez, the attorney that's handling your matter is currently on the record on this case. Once we're done, I'll see if he can meet with you in the breakout room. If you all cannot come to a resolution, and I'm not saying that you need to, but if you can't, then you're gonna have to come in person. I can reset it for you because you can't come today, okay?
Okay.
But okay, I'm gonna put you on mute until I can put him in a private meeting room. Okay, did you send those?
Sorry, what was the email again?
Judge Simmons Courtroom at lansingmi.gov. Okay, while you do that, we'll go off the record. I'll call the next case.
Thank you.
Thank you. I don't know if you want to try to log in and meet with them while he does that, because I'll have an opportunity to get his email and review the pictures.
That's a good idea, Your Honor.
Sounds good. Okay, on the record. Mr. Whitty,
Additional dismissal on ours.
the 245 matter?
What?
Is it 245
No,
matter?
it's a you know, you probably have around a quinkle on it.
Oh, okay,
I
sounds good.
substituted in for her.
Got it. I didn't see it. I just see Kunkel on mine. Okay. On the record in the matter of Foxland Holdings versus Nadej Bilton, file number 24-02195, council appearance.
Good afternoon, Your Honor. Robert Whitty appearing on behalf of plaintiff Foxland Holdings.
And good afternoon, Your Honor. Alyssa Hull with Legal Services of South Central Michigan, representing defendant Bilton.
Oh, okay. I don't even have the appearance on that either. Let's see.
It was filed this morning.
Okay,
I
sounds good.
apologize.
No problem. I just noted it wasn't, it said Kunkel and then it didn't tell me that she had an attorney.
Surprise, sure here.
Okay. Today's the date set for a hearing for non-payment of rent. How are we proceeding?
Your Honor, I'm pleased to report that after quite a bit of conferring, the parties have reached a conditional dismissal in this case. I'm happy to put those terms on the record if pleases the court.
Please do.
Your Honor, there is currently rent to retain through the end of June in the amount of $4,306.38. Court costs are $217.32. Total amount to retain $4,523.70. It's some pretty extensive terms, and I'm happy to read those in. Paragraph 3A provides that the defendant shall pay $775 on the 5th of the month starting July 5th, 2024, and $775 on the 20th of each month commencing July 20th, 24. Paragraph B, payments will be applied first to current month lease obligations and then to the past due arrearage. In paragraph 2, payments will continue until the arrearage is fully paid. Paragraph C, defendant shall remove all trash and debris from the premises and fully clean all bathrooms in the kitchen, including removal of grease, no later than July 10th, 2024, on which date the landlord will inspect the premises. Paragraph D, landlord shall continue to have the right to inspect the premises on 24 hours notice for cleanliness while this conditional dismissal is in effect. Failure to pass or permit any housekeeping inspection shall be a violation of this conditional dismissal. Paragraph E, all future maintenance requests shall be made in writing. With regard to paragraph 4, we checked paragraph 4A with regard to the obligations in 3C and D, and 4B as to 3A and B. So the payment issues would come back without further hearing. If we had one of these housekeeping issues, we'd be before your honor to have the court determine whether or not the agreement was breached. I signed the agreement as did counsel and the defendant, if I may approach.
Yes. Okay. And it's all, that's a complete and accurate understanding of how we're proceeding.
Yes, Your Honor.
You're right, this is some pretty extensive language here. Oh. And ma'am, Ms. Belton, that's how you want to proceed? Okay, so the terms again, as stated, is that you understand or you want this matter to be dismissed today with the condition that you'll pay the past due rent $4,306.38 for support costs, $217.32 for a total of $4,523.70, correct?
Yes, but my point is they're gonna come fix what they need to be fixing there with the windows falling on my kids. But I've been there for 5 years, they don't wanna fix nothing.
It says the landlord shall continue to have the right to inspect the premises on 24-hour notice for cleanliness well, let's see, all future maintenance requests shall be made in writing. So is she gonna have to make new maintenance requests or are there some lingering requests?
The only maintenance request we're aware of is that there's a window that she says is off track.
It's not, it's all windows.
We'll have somebody out to deal with those.
All the windows are off the
Yeah,
track.
they're like coming from the inside. They're not sealing in right.
Are those the only issues you're talking about, or are there some other issues?
They had come fix the other issue on the stairs.
They did fix that
Yeah.
already?
Mhm.
So is that a yes?
Yes,
So it's the windows that needs to be fixed?
yes.
You might as well put it on here. I mean, everything else is on there. That way we don't need her to go put another request in writing. It'll be in writing today.
Your Honor, I just added to the end of paragraph E, plaintiff will promptly inspect and repair all windows.
Okay, thank you. Okay, so, okay, again, back to the terms and conditions. The matter will be dismissed today upon the condition that you understand that you have past due rent in the amount of $4,306.38 for cost $217.32 for a total of $4,523.70. It outlines here how that is going to be paid and the date it's going to be paid, how that money will be applied, and your responsibility as it relates to trash and debris, as well as the landlord's need for access to the premise and their responsibility to maintenance and repair the windows per your request. Okay, and so you understand that you have the right to proceed to a trial in this matter? And you're willing to give up your right to trial for the conditional dismissal? Anybody threatening you or promising you anything to get you to waive your trial? And you understand that if you had any counterclaim that's pending that will also be dismissed, correct? Is there a counterclaim?
No, Your Honor, just affirmative defenses.
Okay, sounds good. So you're gonna give up any of your possible defenses if you enter this agreement. You understand that? Okay, and so you'll get a copy of this, but you need to make sure that partial performance on your part does not absolve you from your responsibilities on that. So you gotta follow all of this if you want to keep this dismissed. Otherwise, if you don't follow any portions of the things that you say you do here, they can request judgment to enter against you immediately without notifying you of another court date. You understand that? Okay, do you have any questions about that?
No.
You have 3 business days from today's date. If once you leave here, you realize you misunderstood the right that you waived, which was your right to have a trial. You can return to the court and request to have this agreement set aside, okay? We'll get you a copy in just a moment. Any additional matters for today's record?
Nothing to complain of, Your Honor. Thank you.
You're all set. Thank you. The record in the matter of Southbrook Villa or Village versus Demaria Caruso, file number 24-02082. Council appearance.
Please, court, Steve Dan, P 782 and 9 for the plaintiff on this matter. We do have a conditional dismissal of terms on the record. We will be submitting under a 7-day rule.
What's your name, ma'am?
Maria.
Why are we submitting it under the 7-day rule and not today?
Because I didn't have conditional dismissal with me, Your Honor.
Do you want me
and
to
given my
print one?
handwriting, so I was going to type it up and get it submitted. So you can read it.
He's here right now. We're all here right now. We can print you one.
Okay. My terms on the record first?
Yes, please.
Okay. So currently there's going to be a total of $9,389.07 due and owing. That represents $91.39 in rent, $250.07 in court fees. The defendant is has agreed to pay her normal rent of $545 on July 1st. She will make a $5,000 payment on July 8th, and the remaining $43.89.07 of the judgment amount is going to be paid. My client has agreed to accept it over 18 payments, monthly payments of $243.07, $243.84 per month for 18 months. We're going to allow her to pay that in the middle of the month. She'll be responsible for paying her monthly rent on the 1st for the next 18 months. Then on the 15th of each month, she'll pay the $243.84. That she does have the option of paying it all at one time, but we did this to allow her to spread out the paychecks. She understands that if she misses any of this payment, we consider the affidavit fall to the courts under the 4B of the conditional dismissal check. She was advised that means there'll be no further court hearings if she misses her payments. I did explain 4.21I to her with regards to her right to an attorney, right to file for the court or jury, as well as a right to come back in 3 business days, explaining that 3 business days is Thursday, Friday, and Monday.
You understand that? Do you have any questions about it? Okay, I don't have the numbers before me because there's no paperwork and I'm not writing that down. So you understand the amount that's past due?
Yes.
And you agreed that that's the amount that's past due? You also agreed to the payment schedule for when it should be paid if you want to maintain possession of the property?
Yes.
Okay, so you want the case dismissed today under the conditions that you'll follow what he stated? Anybody threatening you to enter into a conditional dismissal? So you understand that you have the right to be represented by an attorney today?
Yes.
And you don't have an attorney. Are you waiving your right to counsel?
Yes.
You have the right to proceed to trial. You can demand a jury trial. You understand that?
Yes.
You're giving up your right to trial today?
Yes.
Okay. Again, you have 3 business days from today's date. If once you leave here, you realize you misunderstood any of the rights that you waived, you can return to the court, request file a motion to set aside the judgment. You'll explain to the court how it was that you misunderstood the right that we just went over twice, okay? You'll complete that paperwork, you'll sign it, I'll sign it, and then we'll move on. Partial performance won't satisfy that. So if you don't perform fully as you indicate on this paperwork that you're gonna get a copy of, what will happen is he can request judgment to enter against you immediately and then evict you. You understand that?
Yes.
Okay. Any questions?
No.
Any additional matters?
Ma'am, just give it to the court when I'm done.
Yes, please. Thank you. Mr. Woody left his, what happened to the other Uncle matter?
Hello.
That's good.
Get Sam do it.
Yeah, he only did one and they left. I'm not following.
And then one for 315. I think I found something yesterday.
Who's here for Mr. Wasbury's office? Ready?
It's Mr. Awada.
OPB Partners versus
No.
Naraya and Calvin. Is Naraya West present? Calvin Thomas present? Nobody's here for either party, so we'll dismiss.
One here for Simmons Court.
We have, yes, he's speaking. Judge. Pacific Flats, Juliana Awada.
So,
Scanner stopped
oh,
working.
here he goes. Mr. Brownhouse is busy though. Which matter are you waiting on?
The matters are at 3:15.
Oh, okay. Okay, well, where's our, Garland House is on everything at 2:30, so that doesn't help. I don't know what happened to Mr. Whitty and Anais Baker. That's still on your docket, right?
Yes, let me see. This is more recent than mine.
Is yeah, I don't know what's going on. That was Mr. Bob. He's covering for Dua, correct?
Yes.
I don't know if Mr. Awada is present. Have you seen Mr. Awada?
Well, he speaks French. So,
It should have been an interpreter requested.
yeah.
But today, first court date. then.
Was one requested.
I did. Yeah, we've been having issues. Okay, waiting for Mr. Garland House. Your name, ma'am?
Crystal Page.
You're waiting for Mr. Garland. Okay, sounds good. You're all
All
waiting for
these
the same.
Garland houses.
All of you all have the same attorney for the plea.
No, I did defendants.
Yeah.
Whatever.
Just Winkley, I think is her last name.
I don't know if I did her.
Yeah, I don't know what her date of birth is. Justin Winkley.
Somewhat familiar, but I also don't see it yet.
Yeah.
I know I did. Velma was that.
Yeah, you did do Velma. You
Yeah,
did
she
give
was the young girl, right?
Yep. She was the one that was involved with
the homicide.
Yes.
Oh, boy. Oh, boy. Jesus, help us, Father. Who's talking in the background? The property manager where? The Samsung?
No, with the Pacific Flats, Carissa Williams.
Back on the record in the matter of K North Apartments versus Crystal Page, file number 24-01938. Okay, I do have the photos. I'm sorry, that's not yours. I called the next case. Have you met with her yet?
No, not yet. Your Honor.
Okay.
We do have an agreement for the Lopez matter. Though, if we-
Okay, I'll call you in just a moment. You're gonna have to meet with him privately. No, I don't know why, I don't know whose client that is, but they're supposed to be here in person anyways. Definitely not on Zoom talking about homicides in the middle of a landlord-tenant case, so they can stay in my waiting room, whoever that is. On the record in the matter of K North Apartments versus Jennifer Lopez and Evangelina Rodriguez, file number 24-01939. Council appearance.
Nicholas Garlinghouse on behalf of K North Apartments, Your Honor.
Okay, and I see Jennifer Lopez via Zoom, and then Ms. Rodriguez is also present via Zoom. Today was the date set for a hearing for non-payment of rent. You all did come to resolution?
Yes, Your Honor. We, again, in this case, we filed for a possession judgment and a money judgment in this matter. Ms. Lopez turned in the keys yesterday, so the possession issue has been resolved. However, the money judgment prorated through yesterday's date, since the possession was turned over then, it's an amount of $6,089 plus court costs of $297.73 for a total money judgment of $6,386.73. I explained MCR 4.201 to the party and also got permission from Ms. Rodriguez and Ms. Lopez to sign the consent judgment on their behalf. May I approach, Your Honor?
Yes, please. Thank you. There is no possession judgment because they no longer have possession, correct?
Correct, Your Honor.
No.
Okay, and so Ms. Lopez and Ms. Rodriguez, you want to enter into judgment by consent as to a money judgment amount on this, is that correct?
Correct.
Okay, and so you agree that you owe an amount of $6,089 plus court costs of $297.73 for a total of $6,386.73.
Yes.
Okay. And you're waiving your right to have a hearing or trial on that in order to have this judgment entered against you?
Yes.
And you're also gonna waive your right to be represented by an attorney?
Correct.
And you've given Mr. Garlinghouse permission to sign your name to this document?
Yes.
Do you have any questions for the court today?
No.
You have 3 business days from today that once you leave here, you realize you misunderstood the rights that you waived. You can return to the court, request to have this judgment set aside. We'll set it for a hearing, okay?
Okay.
Okay, where do you want us to forward a copy of this to you?
We can send it to, can you email it to me or does it have to be a physical address?
A physical address that we can mail this to?
510 Mifflin Avenue.
You said Michigan Ave?
Mifflin.
Spell that?
Mifflin. Baby stop.
Okay. Is that in Lansing?
Yes, ma'am. I believe the area, Mom, what's the area code?
Can you unmute, please?
I'm sorry, I thought I was. It's 48912.
Okay, 48912. We'll have
Yes, ma'am.
that sent out. Any additional matters for today's record?
No, Your Honor.
Thank you. You're all set, Ms. Rodriguez, and you're all set, Ms. Lopez. Good luck to you with your daughter.
All right,
Thank you.
thank you.
Thank you. Back on the record in the matter of Stone Ridge Meadows versus Emeka Ochonu. I did receive the photos that you provided to the court that I believe indicates that there's some water damage and mold, I think you said, in the bathroom. These are bathroom cabinets. And then,
Sorry, those are my kitchen cabinets.
okay, so you have mold in the kitchen
Yes, I
and
have
the
it.
bathroom, or, okay.
I do apologize. It's
Kitchen cabinets and bathroom, okay.
And then in the wall in my living room as well, and in the window sills of all my windows.
You put in a request to have that addressed, and how was that addressed?
They came and they sprayed my window sills with a mold and mildew spray by Clorox. And then they gave me the rest of the bottle to say to use it for when I see it. I asked them how they're gonna address my bathroom and my cabinets, and they said that they will come back to it another time, and I've never heard anything back from them regarding that matter.
Let me see. Let's try this again. Okay. Okay, so this is where?
Sorry, that's in my my closet to my bedroom. The shower's on the other side of it, and that's a pattern that's in my carpet also as well.
I don't know why this won't let me make it any bigger, but it won't. Okay, that's in your bedroom?
Yes, that's in the closet in my bedroom.
That's a bathroom, obviously.
Yes,
This looks like a ceiling where?
of the bathroom.
In the shower?
Yeah, that's the ceiling of the shower.
Okay,
Yeah.
and this is a cabinet, kitchen
Those
cabinets?
are my kitchen cabinets right here.
Was there a leak in there of some sort?
Never, that since I've been there, since the 4 years I've been there, I've never had a leak in my cabinets. That's under my air conditioning unit in my living room. And that's just another one of the cabinets.
Okay, sounds good. Any other conditions of the property that you believe give you a lawful right to withhold your rent?
They have entered my apartment multiple times without even the property manager knowing. Even the last time, just a few weeks ago, I recorded the encounter because I went to the leasing office to figure out why my apartment was entered without notifying me. And at the time, the property manager herself didn't even know why the maintenance team had entered my apartment. Also, as well, she tried to kick me out of the office because she said that my mannerisms needed to be turned down. That is the verbatim of what she told me. That I needed to turn down my mannerisms. Before.
When was this incident? You said recently?
Yes, ma'am. The time that they entered my apartment, it is last month. I'm sorry, I would have to check my phone to see when the video was, but I have the exact date.
Video of when they entered your apartment?
No, I apologize. I recorded myself going to the leasing office, talking to the property.
Okay, and they had no knowledge of why?
Yes, ma'am.
Okay.
I even have on the video the maintenance team coming to the property manager and telling her that he entered my apartment.
And didn't tell you why?
They told me why at the time. They told me that there was a maintenance emergency. There's a main water line that's in a closet in my living room. And when I was asking at the time, I was just saying that I still need to be notified because even if the maintenance enters for a maintenance emergency, not even the property manager herself knows. So it's pretty scary for me to go to the property manager herself. She doesn't know what's going on. I don't know what's going on. I just know somebody was in there.
How did you know someone was in there?
Things of mine were moved and they weren't as I left.
Okay, but no one left any indication that we entered your property today or anything like that?
So it was a closet where the main water line was. So,
I recognize that, but I'm saying no, they didn't leave you a notice, because typically you get a notice in advance. I don't know if your lease requires 24 hours, that's typical. 24-hour in advance notice that they're gonna enter the property. But if there's an emergency, such as what they're stating, typically it would be a proper practice to leave notice that we have entered your property. You didn't
yes,
have
ma'am.
that.
No, there was no note left. There was nothing. There was no indication. No one told me anything.
Okay. Any other, and you said this happened multiple times?
Yes, this happened multiple times.
How many times?
Probably four different times.
All for a maintenance emergency?
That's what they say it is.
Okay. Any other conditions?
No, not at this time.
Thank you. Did you want a question?
Yes, just a couple questions, Your Honor. So looking at the issues that you're bringing up, the mold, you say that you were left with that spray and things to use as well after they had sprayed down the mold.
Oh, sorry,
correct?
sir. They only sprayed down my windowsills. Yes, they came into my apartment. They sprayed the windowsills where also the mold was. They sprayed out the windowsills and cleaned the windowsills, and they left me the rest of the cleaner to spray the other areas that I had issues with.
Okay, and did you do so?
I could not spray a ceiling with mold cleaner, so I did not at the time. I mean, I could spray it, but I mean, it, in my opinion, needs to be replaced, like repaired, instead of just a spray.
Do you have anything indicating that there was not issue with the main water line going into the?
No, sir, I was at work at the time, so I do not have any evidence to say if there was a true issue for them to enter my apartment. I just have them admitting them and that they had no knowledge, the property manager had no knowledge of it at the time.
Okay, but when you were talking to them, the maintenance people did explain why they did.
After I was speaking with the property manager in the leasing office, as she was trying to kick me out of the office, the maintenance man happened to walk in at that same time. So he was able to explain to us at that time his reasoning why he entered.
Okay. And I have no other questions for.
Thank you. Any other witnesses that you intend to call, or that was it?
That's it.
Okay. You calling rebuttal witnesses?
Yes, Your Honor. Call Ms. Wendy Martin as a rebuttal witness.
Okay, thank you. You're still under oath, ma'am.
Ms. Martin, again, in your position as with Stone Ridge Meadows, are you familiar with maintenance requests and those records as well?
Only if I ask. It's not something that I deal with directly. I have to ask which maintenance.
Can you speak up a little louder, please? Sure.
Okay. You want to repeat that then?
Sure. I don't deal with maintenance directly, but if there's an issue, I reach out to whomever needs to answer those questions. I don't deal with it directly.
Okay, so by that, do you mean that when a maintenance call comes in, you direct where that call goes to, or you just, you don't handle the maintenance requests?
I don't handle them unless it becomes an issue.
Okay. All right, to your knowledge then, were there any issues that came to your attention maintenance wise regarding this particular unit?
No.
Okay. Then I have nothing else, Your Honor.
Thank you. You can make Susan stand. You can make your argument.
Okay, thank you, Your Honor. Your Honor, the amounts in dispute for the rent have not been contested at all, so I will leave the ledger to speak for itself with the amount that's owed, the $4,279.50. As to the arguments that rent should be abated, I don't believe that, first off, I guess I will just state, I don't believe that the exhibits were entered properly with not having us able to see them before today's date, and that argument never coming up in any form of answer or any response.
It's a hearing, and he's representing himself, and so I can be very judicious and liberal. So they were admitted properly. And your person is the owner of the property. They, inspect the property if they don't think these are legitimate, and I can give you time to do that if you'd like that.
That's all right.
Thank you.
I will say from the photographic evidence that we do have that's been admitted, I don't see anything that rises to a level of making the property uninhabitable. Again, yes, Mr. Tonu is still residing in the premises, and maintenance did respond and take some actions toward the issues that he was
He gave him some spray.
Yes, correct, which he also did not use, Your Honor.
Okay, so your position is that people can live with mold in their house and just spray it?
I suppose it depends on the type of mold. We don't have any evidence.
Agreed.
Yes.
Do we know what type of mold it is?
We do not.
Okay, if I notify my landlord that there's mold and they just give me some spray, does that make me feel like they even took effort to find out what type of mold it is? Or was that his responsibility to find out what type of mold it was?
Well, as to the type of mold, yes, we don't know what that.
It's his responsibility to find out what type of mold? Is
No,
it?
Your Honor.
Okay, it would be your client's responsibility then, correct?
Yes, to remedy the situation, at least in some fashion.
Okay, and there's no evidence that they, based on his statement, that the only thing they did was spray something in the window, not in any other areas, which I see mold in the bathroom, in the ceiling, I see mold around the tub, I see mold in his kitchen cabinets, which is where he's supposed to keep his food, and mold in the bedroom. And he's supposed to just spray something, not even clear what type of mold it is. Looks black to me in the pictures, but we don't know, because I'm not a mold specialist, he's not a mold specialist, you're not a mold specialist. But the responsibility would not be his to find out what type of mold, correct?
It would not be his responsibility to get that tested.
Very good. Okay, and so, but you all obviously agree that people don't have to live with mold and that mold is a hazardous contamination in your home, correct?
It certainly can be, Your Honor, yes.
But you don't believe that that rises to the level of any abatement?
Your Honor, I don't see anything that, yeah, has impacted this particular plaintiff. There's no issue of any argument regarding health hazards that have been caused by it or health effects.
Oh, so unless he has health effects, it doesn't matter. That's the only time it's an abatement, if he gets sick.
No, Your Honor, as to uninhabitability, I would say that's.
Well, I see some empty cabinets. Where are you keeping your food, sir?
I try not to use those cabinets because I don't want to get sick from that.
It's clear from these pictures, and I can put them back up if that'll help you, that there is some kind of leak that has happened there because the wood has got a wet stain on them. On more than one level of the cabinets. There's clearly something going on in the ceiling or behind the wall for there to be black mold coming into your bathroom. That's not normal. Into your shower. I don't know what this is on the floor or on the side wall or in the bedroom on the carpet. I don't know. It's not my responsibility to inspect it. It was your client's responsibility to inspect it and to tell us what kind of mold is versus giving someone some bleach or spray and tell them to fix it themselves. That's disgusting. And quite frankly, I think it's time that the people who want to hold these rental leases and cause people to pay market rent keep their properties in livable conditions, including if there's a request about mold, you take it seriously. And giving someone a bottle of bleach or spray and telling them to just spray it like they're killing bugs is a problem. You don't even know what kind of mold it is. And he doesn't have to wait until he has a hospital bill because he's got something in his lungs before it becomes an issue. It's an issue now, at least for this court. I'm going to order that your client, I'm going to set this out, your client's going to go and get a mold test examination done. I want to see the report.
Do we have a date for?
I'm going to give you a date. You need to be escrowing your rent. Have you been escrowing your rent?
I do not comprehend what that means. No, I don't know.
So the law does not require you to just keep your rent because you don't like what they're doing. You get to act in good faith, meaning I put my rent in the escrow account at the court, not the escrow of your choosing. You go to civil department, tell them you need to escrow your rent each month because you did not dispute that you owed past due rent $4,279.50. However, you said that the reason why you didn't were for multiple things. Number one, a new lease and your lease not being signed. That's not going to get you anywhere, at least not with me. When you don't sign a new lease, you become month to month, so you're month to month. The issues, the court could care less about the fact that your tower rack was broken. I think it should be fixed, but do I think that you don't got to pay your rent because of that? Of course you got to pay your rent because the tower rack's not broken. You just got to hound these people to get it fixed, put it in writing. And then if they don't reply to your request, that's when you come to the court because you could have sought action before they sought action against you and ask the court to make them take care of the maintenance issues. The mold issue is a concern for me because that's a health hazard. And people shouldn't have to get lung cancer or anything else before they get any treatment done for their house. And giving someone a bottle of spray for mold is not sufficient. But the broken tower rack should be fixed and they'll fix it, I'm sure, when they go to test that mold. I'm positive. And so the burn issue, you caused the damage. I believe they should fix it, but I don't know that they're going to fix it and not charge you for it because you caused the damage. Let's see. The entering into your property without permission is concerning. I recognize that there is a water main or water access that may be in your unit. And it makes sense now that I'm seeing this mold, that maybe there is an issue and it's stemming or that's connected to your unit, which is all the more reasons why they should be trying to investigate why you're having this mold issue. Something's going on in your unit for you to have mold in all these areas of your home. But nonetheless, they should be notifying tenants when they're entering someone's home. Tenants shouldn't have to feel like they found out by happenstance because something was moved into my house. It's a responsibility for them to give you notice in advance unless there's an emergency, to which, if there's an emergency, a note could have easily been left on your table or in your unit. We entered for X, Y, and Z purpose. But that sounds like there's a greater issue going on in the management office if the management didn't even know why they entered in there. The communication between maintenance need to be well with management as well. Maintenance should be notifying. We have an emergency so that management knows, and it could be noticed, and maybe management will email you, we had to enter your property. But that's an issue that they need, an internal control issue that they need to resolve. And I think that is an inconvenience. Whether or not you're going to not have to pay rent for that, that's questionable. But I'm more concerned about the mold. And so I believe that he is entitled to some abatement. I don't believe it's $4,000 worth of abatement, but I think that he's suffered some harm. But I want to know what kind of mold this is before I decide how much harm he's potentially suffered. So let me get your new date. It's gonna probably take them a couple weeks to get someone out there for the mold. So what's our next available date though? You do the July 24th at 1:30. Do you have any questions for the court today?
Not at this time.
We'll get you a copy of your notice to appear. So like you're here. Any additional matters for the record, counsel?
No, for me, Your Honor. Do you want the marked exhibit for the file?
Yes, let me give you this one and I'll take that. Thank you. Okay, then Mr. Garlinghouse, you have two other people waiting, I think. Crystal Page and then Anthony Silvertooth.
Yes, Your Honor.
Thank you. Okay, Ms. Paul, you're representing Talisha Washington.
Yeah, Talisha Washington and Rosalina Moreno.
They're both on Zoom.
Yes.
Is Mr. Owaka present?
Yes, ma'am.
Okay, with a interpreter.
Yes, just,
Of the record in the matter of Pacific Flats versus Liana Wata, file number 24-01394. Counsel, have your appearance.
Yes, good afternoon, Your Honor. Ronald Bach here on behalf of Sam Dula for plaintiff Pacific Flats.
Thank you, and we have Mr. Owaka present, and there's an interpreter. State your name, sir.
My name is Patient Baraka, P-A-T-I-E-N-T, Baraka, B-A-R-A-K-A.
Raise your right hand, sir. You solemnly swear or affirm that you'll interpret in the matter before the court completely and accurately and not divulge confidential communication to help you God.
Yes, I do.
Thank you. Today was the date set for hearing.
Aujourd'hui, c'est le jour que nous sommes, qui était prévu pour la procédure.
For non-payment of rent.
Pour n'avoir pas payé le loyer.
How are you proceeding, counsel?
Yes, Your Honor, we've spoken. He's got 2 applications for aid pending, or assistance pending, and also one through his employer. We thought it would be best to adjourn this out 4 weeks, and then when those come in, we can likely make an agreement on whatever portion is left over.
L'avocat vient de dire que vous êtes convenu, vous êtes entretenu et vous êtes convenu que vous êtes en train de chercher les moyens, vous avez des applications qui ont été soumises quelque part, ici d'application here. Des applications qui ont été soumises et vous avez aussi repris le travail, vous espérez obtenir un revenu à la fin du mois et donc vous serez capable de payer.
Yes, 3 applications pending.
Well, the one from Someone Lennon, I believe is an employer.
Got it. Okay, so we'll stay the case actually. This, I'm sorry. Yeah, we probably need copy because we have to put a stay with the copy of it while they process the application. But I am gonna set the date today for the next date, not next available date. I'm gonna do it. Date after the next. I think I actually gave you my my docket sheet.
Wait a minute.
July 31st.
Thank you. July 31st
Juillet le 31.
at 1:30 will be the next date for status.
13h30. Juillet le 31. 13h30.
We'll get you a notice.
Thank you, sir.
Give me just a moment. Is that date still good?
Yeah, it's already stayed.
It is. Until when?
It was put in there the last year. So what was that, May 8th?
Oh, that's fine. So we don't need another statement. Sounds good. We'll just take a copy of the paperwork. We'll get you notice. You're all set.
Thank you, Judge.
Thank you. Ms. Hollow, I'm not, who's the plaintiff's counsel?
Me.
Oh, okay.
We just,
You're two. There's 2 though, so you're on one of them. You're
Attorney Reyes.
Moreno on one and Reyes on the other. Okay. On the record in the matter of Trinity Properties versus Rosalina Moreno, file number 24-02271, counsel appearance.
yes, good afternoon, Ronald Bach here for Plaintiff Trinity Properties.
Alyssa Hall with Legal Services of South Central Michigan for Rosalina Moreno.
Okay, Ms. Moreno, can you hear us?
Yes.
Very good. Today was the date that was set for hearing for non-payment of rent. My understanding is that there is a conditional dismissal.
Yes, Your Honor, it's my understanding it was e-filed yesterday, but I do have a copy here. It's not signed by the defendant, but I was just asked to put it on the record today.
Was the e-file copy signed by the defendant?
Yes.
Okay, put the terms on the record, please.
Certainly, Your Honor. I was just, parties hereby enter conditional dismissal under the following conditions. Case is dismissed without prejudice, subject to the conditions below. Defendants agree to move out. Defendant shall move out of the property and surrender possession entirely on or before July 8th. Should defendant default on the terms, the action may proceed without notice to the defendant. An action will be reinstated upon plaintiff submitting affidavit of default, order for reinstatement of the case, a judgment for possession, and an order of eviction, which will enter simultaneously. With the exception of the enforcement of the settlement, which shall be considered the final order of the case before the court. The Honorable Court shall retain jurisdiction of this matter for enforcement of the terms contained herein. It's basically just a surrender.
That's complete and accurate, counsel.
Yes.
Can I see a copy? Because my on basis, I don't need a signed copy. I just need the terms. Thank you. Okay, and so Ms. Moreno, what the council read about the conditions of the dismissal, that's accurate?
Yes.
Okay, so you want the case dismissed today? You are going to move out of the property and surrender possession entirely on or before July 8th, correct?
Yeah.
Okay, you understand your right to pursue a trial on this matter, correct?
Yes.
Are you waiving your right to trial?
Yes.
Okay. You understand that partial performance of this agreement won't satisfy. You have to move out completely, turn over the keys, and not leave any trash or debris for them to have to clean up. You understand that?
Yeah.
And it
Yes.
has to be before July 8th. You have 3 business days from today's date. If once you leave here, you realize that you misunderstood any of the rights that you have just given up, you can return to the court, request to have this agreement set aside, and we'll set it for a hearing, okay?
Okay.
Any questions for the court, Ms. Moreno?
No.
The additional matters for the record, counsel.
Oh, yeah.
No, Your Honor. Thank you. You're all set.
Thank you, Judge.
Oh, well, on base is frozen. I have to restart it. Let's see. Oh, that messed up before. Well, let me see the 315.
This is the first.
I only have stuff up to 3 o'clock. I mean, 2:45. Why do I not have any 315?
Oh, I didn't
Yeah,
say
don't worry.
315.
We're doing matters on this.
I think that was my last due matter.
Thank you. Have a good day.
Same to you. Got a water we just reset.
No, we got the whole 3:30.
No, I'm talking about in on base.
Oh. I'm sorry. Since administration told us to fill this out.
We actually already have, I don't pull those out. So.
They,
that's what I
yeah,
thought.
that, he has to go to admin.
That's what I said, and he said they told him that to give it to me to fill out.
No, no, they can fill it out. We're in the
Yeah.
on base court with zone.
Oh, just have
We said
security.
defendant has apps today. Okay, on the record, in the matter of Woodbridge Common versus Talisha Washington, file number 24-01947, council appearance.
Alyssa Hall with Legal Services of South Central Michigan for defendant Washington.
Good afternoon, Your Honor. Jeffrey Ray on behalf of Woodbridge.
Okay, today was the date set for a hearing for non-payment of rent. I understand there's a conditional dismissal, and for the record, Ms. Washington is present via Zoom. Council, can you put the terms on the record?
Yes, Your Honor, the parties have reached a consent order for conditional dismissal to submit to the court. The defendant shall pay the following to plaintiff. Rent through June 30th, 2024 is $3,769 with court costs of $181.60 for a total $3,950.60. Beginning in July 1st, 2024, defendant shall pay her monthly rent obligation on time each month, and in addition shall pay $800 towards the total listed in 2D during the course of each month. This is subject to 4B notice requirements, and partial payment by defendant shall not suffice in this matter, and it's signed by plaintiff's counsel, myself, defendant's counsel, and Ms. Washington, the defendant.
Was that already uploaded?
It is in my file.
Yes, please. Okay, and so Counsel Ray, that's complete and accurate understanding of the resolution.
Yes, it is.
Okay, and then Ms. Washington, that's how you want to proceed, is with a conditional dismissal? I didn't, oh, you're muted. Can you unmute?
Yes.
Okay, very good. So you agree that the past due rent to retain possession is due and owing $3,769 plus court costs of $181.60 for a total of $3,950.60. That's due through the time period of June 30th, 2024. That beginning July 1st, 2024, you shall pay your monthly rent obligation on each month on time, and in addition, pay $100 a month toward the amount past due during the course of each month, correct?
Yes.
Okay, and you sign that agreement. You understand that partial performance will not satisfy this conditional dismissal?
Yes.
Okay, so if you don't perform any portion of this agreement, they have the right to re-enter this case against you and have judgment against you entered immediately without notifying you of a next court date, okay?
Yes.
Okay, and so you have 3 business days from today. If once you leave here, you realize that you misunderstood any of the rights that you had to give up, which in this case was your right to a trial. You can return to the court, request to have this agreement set aside, okay?
Yes.
And I did sign this one, but you have one in the system. I'm not gonna have this uploaded. I will sign the one in the system. Any additional matters for the record?
Nothing for me. Your Honor.
Thank you. You're all set.
Thank you.
Thank
You're
you.
welcome. Thank you. Let's see. It's processing. Library. So weird.
Bellingham has one other person that's from here.
Yeah, he was advised.
Johnson, right?
Mr. Brownhouse, are you ready?
Yes, Your Honor, we have an agreement for conditional dismissal.
On the record in the matter of the people, I'm sorry, wrong date. On the record in the matter of Cape North Apartments, which is Crystal Page, 124-01938, council appearance.
Good morning or afternoon, Your Honor. Nicholas Carlinghouse on behalf of K North Apartments.
You have to state your name, please. Crystal Page. Okay, today is the date set for a hearing for non-payment of rent. There's going to be a conditional dismissal. Please put the terms on the record.
Thank you, Your Honor. Your Honor, the terms of the conditional dismissal are as follows. The current balance due after plaintiff has received a payment of $1,500 in cash and $1,000 in money orders from the defendant toward the balance, and plaintiff is writing off $600 in late fees. So that leaves a balance of $1,225 in rent owing, plus court costs of $258.34, which is a total of $1,483.34. And the agreement is also that defendant will pay monthly rent as it comes due on the 25th of each month going forward, plus any amount toward the remaining balance, the $1,400 amount, as her budget allows for. We also explained the MCR 4.201 about the 3 business days to have the consent judgment set aside, and may I approach with that?
Yes, please.
It's signed by both parties.
And Ms. Page, that's how you want to proceed with the conditional dismissal? Yes. Okay, so you're agreeing that the past due rent owed at this point is $1,225 plus court cost of $258.38 for a total of $1,483.34. And that's due through the time period of July 24th, 2024.
Correct, Your Honor. Payments, rent comes due on the 25th of each month.
Okay, so that's her, she has rent due as of yesterday. is what I'm saying. Okay, and so as this plaintiff has received payment of $1,500 in cash and $1,000 in money orders toward the balance, plaintiff is writing off $600 in late fees. Defendant shall pay monthly rent as it comes due and on the 25th of each month, plus any amount towards the remaining balance each month as her budget allows. You understand partial performance of this agreement won't satisfy the agreement, correct? Correct. So that means if you don't comply fully with what you stated you would do here, they can enter judgment against you immediately without noticing you of any future court date, okay? You've already signed this. You have the right to be represented by an attorney. You're giving up your right to have an attorney if you enter into this agreement. That's what you want to do? Yes. You also have the right to proceed to a trial. You could demand a jury trial. Did you want to give up your right to trial? You have 3 business days from today's date. If once you leave here, you realize you misunderstood any of those rights, you can return to the court and have this agreement set aside, okay? Okay. We'll get you a copy in just a moment. Any additional matters for the record?
No, Your Honor.
Thank you. And you have to meet with Mr. Silvertooth?
Yes, Your Honor.
Okay. Ms. Cole, who are you waiting for?
Your Honor, I'm just here with our summer law firm.
Oh, okay. Sounds good. Who was this waiting?
She is waiting for.
What's her name? What's your name?
Ruth, there's Ruth Peak, Eureka Peak.
Erica.
Oh, Erica. Erica Peak. She's waiting on Plug.
Who?
Plug is,
Klug.
Klug. I'm sorry.
And who's the other person waiting?
Marquita Johnson.
Where's Mr. Klug? You don't know?
No.
We've not seen him?
Seen him. Let me, I'll check again.
Because it's been 20 minutes and I'm gonna dismiss the case in 30 seconds. This wasn't reset. Well, my note says that actually. The Doe one says May 22nd. Reset service by attachment. May 22nd. Oh, we did that one from this morning where the guy said it was a reset, the person down. So that should have been a default. I don't know who the attorney is. If we can let them know, it should be a default. We can email them that. We can file. Person Doe. Fannie Mae versus person Doe.
Your Honor.
Yes.
Buchanan said that he was down there about 10 minutes ago, and she hasn't seen him since.
Was he
Cool.
Forest?
Huh?
Was he in Forest?
No, I just checked over there.
He's not in
That
Ward.
was- That was the one I saw. That wasn't Cool.
And he's
Who
not
was
in,
the one that was on Zoom this morning?
he was, he's not in wards either,
No.
or any private meeting rooms with anybody.
I just checked on the conference room. I'll check Flores again.
You didn't even check in here. It's 4 o'clock. It is. We set that for here. Are you here for Clue?
Yes, I am.
Oh, okay, because we didn't know anybody checked in for Clue. We were gonna dismiss these cases.
I thought I mentioned that in the hallway earlier. I apologize.
You mentioned it to whom?
The individual with the sign-in sheet. I was working with Flores. That's my mistake. I should have.
Yeah, this is, I'm Simmons.
I know, I was working with Flores and then she came out and asked if I was here for Simmons. I said for later. That's my fault, Your Honor.
Okay, there was a 3:15 and then there's 3:30s.
Yes.
Are you ready?
Yes.
Okay. On the record in the matter of SK Lansing Limited versus Karen Roberts, file number 24-01200, council appearance.
Postman on behalf of the plaintiff. Actually, Alyssa Hull on behalf of Karen Roberts.
Okay.
Defendant, this matter was submitted, stipulated dismissal. Order was submitted, I believe, on Monday in my file.
Did you talk to her earlier today? Thank you. Let's see here. This is for Roberts. You say you submitted dismissal. Related item. Dismissal stipulated and ordered. Oh, looks like I already signed it. I don't know why they didn't pull it from the docket. I signed it already. Okay, thank you.
Thank you, Your Honor.
Do they need any date? I didn't see
For
us an
Roberts?
adjournment, a stipulation to adjourn.
No, adjournment, dismissal.
This is to my file, it says to adjourn by stipulation.
Karen Roberts, it's a dismissal and I already signed it. I signed it on the 24th. I don't know why civil didn't pull it, but nonetheless. On the record in the matter of SK Lansing Limited versus Marquetta Johnson. File number 24-01190, council appearance.
So on behalf of the plaintiff.
State your name, please, ma'am.
Marquita Johnson.
Okay, Ms. Marquita Johnson, today is the dates up for hearing for non-payment of rent. Council, how are we proceeding?
Had the opportunity to speak with the defendant and we've entered a conditional dismissal. I can put those terms on the record for you, Your Honor.
Yes, please.
Rent outstanding through June 30th, 2024 is $2,888.63. Court costs of $177.04 for a total outstanding balance of $3,065.67. Defendant is to make the following payments: $510.95 on or before July 19th, August 19th, September 19th, October 19th, and November 19th, and a payment of $510.92 on or before December 19th, 2024. Defendant will pay monthly rent on or before the 5th of each month, and rent is currently $328. 4B is checked and 7 is checked. Both myself and the defendant have signed that agreement.
Okay. Okay. You have a new last name?
No, I've been out here saying last name for like 12 years. I don't know why.
You don't know why they have it as Johnson? Your last name's not Johnson?
That's my maiden name.
Oh,
My married name is Benson.
Okay, when you signed your lease, you used Johnson?
When I signed my new lease, I used Benson. So my old lease is Johnson.
Yeah, I'm not sure why it says Johnson, but I see you signed Benson, that's why I asked. Are you making a motion to amend to AKA Marquita Benson?
Yes, Your Honor.
Motion is granted. Okay, so you want the case dismissed today upon the condition that you'll pay past due rent in the amount of $2,888.63 for a cost of $177.04 for a total past due amount of $3,065.67. That's for rent due and only through June 30th, 2024, correct? Okay, and that you'll make the following payments: 5/10/95 on or before July 19th. You'll make that same payment on August 19th, that same payment on September 19th, October 19th, November 19th, and 5/10/92 on or before December 19th. As a defendant will pay monthly rent obligation on or before the 5th of each month. Rent is currently in the amount of $328. That's accurate?
Yes.
And you understand that partial performance won't satisfy this. So that means you can't just pay the 5/10/95 and then you didn't pay your rent on time. You got to comply completely and accurately as of what it states here. Otherwise, they can request immediate judgment against you without notifying you of another court date and evict you from the property. You understand that?
Yes.
Okay, you have the right to be represented by an attorney today. Did you want to give up that right? I can't hear you. You don't want to, you don't want to give up the right to be represented by an attorney? You want to get an attorney to represent you?
No, yes.
Oh, so you do want to give up the right, okay. You also have the right to have a trial. You could demand a jury trial in this matter. Do you want to give up that right as well?
Yes.
Okay, you have 3 business days from today's date. If once you leave here, you realize you misunderstood those rights, you can return to the court, request to have this agreement set aside, we'll set it for a hearing, okay? Do you have any questions for the court? We're gonna get you a copy of that in just a moment. Counsel, any additional matters for the record?
No, Your Honor.
Thank you, you're all set, man. Thank you. On the record, in the matter of SK Lansing Limited versus Erica Peak, file number 24-01206. Appearance, please.
Sullivan on behalf of plaintiff.
Ma'am, what's your name?
Erica.
EREKA. Thank you. Today's the date that was set for hearing for non-payment of rent. Counsel, how are we proceeding?
Had an opportunity to speak with Ms. Peak, and at this point, we respectfully request an adjournment to the court's next available date.
What is the purpose for the adjournment?
There's some issues with the ledger that need to be resolved on the tenant's end and on my client's end as well.
July 31st at 1:30.
Thank you, Your Honor.
No problem. Do you have any questions for the court today, Ms. Peak?
No, ma'am.
We'll get you a copy of your notice to appear. Any additional matters for the record, counsel?
No, Your Honor.
You're off the record. Sorry. We have one more. On the record in the matter of SK Lansing Limited versus Shannon Reese, file number 24-01207. Counsel appearance.
Alex Sullivan on behalf of plaintiff.
What's your name, ma'am?
Shannon Reese.
Thank you. Today's the date set for hearing for non-payment of rent. Counsel, how do you want to proceed?
Had the opportunity to meet with the defendant, and we've come to a conditional dismissal, and I place those terms on the record for you, Your Honor.
Yes, please.
Rent due through June 30th, 2024 is $2,475. Court costs of $177.04 for a total balance of $2,652.04. Defendant will make the following payments: $442 on or before July 19th, August 19th, September 19th, October 19th, and November 19th, and a payment of $442.04 on or before December 19th, 2024. Defendant to pay rent on or before the 5th of each month. Rent is currently $309 per month. 4B is checked and 7 is checked. Both myself and the defendant have signed that agreement.
You can approach counsel. Thank you. Okay, and Ms. Reese, that's complete and accurate as to how you want to proceed, correct? Is that a yes? Yes. Okay, so you agree the past due rent is owed in the amount of $2,475 for a cost of $177.04 for a total $2,652.04. That includes rent due and owing through the period of June 30th, 2024. Is that a yes? Okay, you want the case dismissed upon the condition that you paid that amount. It says defendant will make the following payments: $442 on or before July 19th, August 19th, September 19th, October 19th, and November 19th, and $442.04 on or before December 19th, all 2024. The defendant will also pay rent on or before the 5th of each month. Your current rent is $309. That's correct? And that's your signature? You understand your right to be represented by an attorney during this eviction proceeding? Are you willing to waive your right to counsel? You don't want to waive it? You want to get an attorney?
No.
Oh, okay, you want to waive your right to counsel? That one always gets people. I don't know why. Okay, and so you also have the right to proceed to a trial. You could have demanded a jury trial. Do you want to give up your right to a trial? You do not. You want to have a trial?
No.
Oh, okay. So you do want to give up the right to trial, correct? Okay, case will be dismissed today as long as you follow those conditions. Partial performance will not satisfy this. You heard me tell the other person, you got to do everything you said you're going to do right here to the T. Otherwise, if you don't, if, for example, you on December 19th pay $442.03, they can request judgment to enter against you immediately and for you to be removed from the property for that 1 cent. Now, I probably would set it for a hearing, but they could do that, okay? So you need to make sure you follow this to the T, okay? You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you gave up, and you want to come back and say, no, actually, I did want my trial, then you need to come to the court and file a motion to have that set aside. But you only get 3 days to do that, okay? 3 business days. Do you have any questions? Any additional matters for the record, counsel?
No, Your Honor.
Thank you, and thank you, Ms. Tolzman. She was looking for Mr. Klug this whole time. She didn't realize.
I'm sorry. I should have confirmed. I should have came back in here before I started talking to them.
I said, we haven't seen Mr. Klug. What's
That's my
going
fault.
on?
Mr. Klug sent me this afternoon.
Sounds good. Thank you.
She gave me the defendant's name.
Totally my fault. I should have came back in. I'm so sorry.
Let's see.
Well, I lost about 5 pounds.
She's looked in every courtroom, every office. Where's
did this girl
Mr. Klug's
go?
not here. And then you said Judge Buchanan said Mr. Klug was there 5 minutes.
Yeah,
She did.
She did. Literally. Mr. Klug is on Zoom. I pulled the short stick as one
Got it.
person. He got the Zoom hearings.
She literally said he was just down here 10 minutes ago.
Okay, Mr. Garlinghouse, you have one more.
Yes.
Correct?
Have a good evening,
Same
everyone.
to you.
Thank you.
K North Apartments versus Anthony Silvertooth Jr. Council appearance, please.
Good afternoon again, Your Honor. Nicholas Garlinghouse on behalf of K North Apartments.
What's your name? Okay, Junior? Okay, very good. Today's the date and time set for hearing for non-payment of rent. Mr. Garlinghouse, how are we proceeding?
Your Honor, we've come to an agreement for a conditional dismissal.
Terms on the record, please.
Thank you. Your Honor, current terms of conditional dismissal are there's current rent owing through July 24th, 2024 of $681.92 plus court costs of $237.74 for a total of $919.66. Silvertooth has agreed to pay that balance on or before July 12th of 2024. Failure to do so would result in filing of an affidavit and judgment being entered with no further proceedings. Partial payment will not prevent an issuance of an order of eviction, and MCR 4.201 was explained to Mr. Silvertooth. May I approach?
You may.
Thank you.
Okay, let's see. And so, Mr. Silvertooth, that's how you want to proceed today?
Yeah.
Case will be dismissed today upon the condition that you're agreeing to pay past due rent $681.92. That's due through a period of July 24th, 2024. Court costs $237.74, and a total amount due $919.66. Correct?
Yeah.
Okay, and that you'll pay that on or before July 12th, 2024. Correct? Okay, and you sign this document? Is that a yes?
Yeah.
You understand that you have the right to be represented by an attorney during this eviction proceeding?
Yeah.
Want to give up your right to be represented by attorney?
Yeah.
You have the right to proceed to trial. You could have a jury trial. Did you want to give up your right to trial?
Yeah.
Okay. You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you waived, you can return to the court, request to have this set aside. Partial performance will not satisfy this. You got to pay the amount here of $919.66 on or before July 12th. Otherwise, they can enter judgment against you immediately without another court hearing, and you could be evicted. Do you understand that?
Yeah.
Any questions? Any additional matters for the record?
No, Your Honor.
Thank you. You're all set. Was Mr. Whitty supposed to be here for Jasmine Powell, Roy Powell, and Robert Taylor? I don't see anything.
I did see Mr. Whitty a while ago.
Mr. Whitty was here earlier on one thing, but then there was 2 more things I thought he was supposed to be here on, but he didn't come back. And so they're gonna be dismissed. I didn't mean to do that. I don't know what that means.